Welcome to the Assureology Show, a growth hacker's guide to human capital management with your host, Mike Vannoy. Each week, we bring you experts in human resources, employment law, accounting, benefits planning, and more to build productive organizations. You'll gain practical guidance for your business. You'll be alerted to the latest news and mega trends that impact small and mid-sized companies. We'll give you the hands-on information you need to stay compliant with ever-changing employment laws, the strategies you need to win the war for talent, and much more, so you can focus on what you do best, growing your business. Enjoy the show.
Top 5 employment-related lawsuits and how to avoid them. Hi, I'm Mike Vannoy with Assure. Have a great guest to unpack this topic today. My guest is Brian Shenker, a New York-based attorney with the office of Jackson Lewis. Brian's practice focuses on representing employers in a wide range of workplace matters, as well as preventative advice and counseling. Brian has extensive experience in defending class and collective action lawsuits under federal and state wage and hour laws. He has successfully defended wage and hour audits conducted by the U.S. and New York State Departments of Labor. Brian regularly handles cases before courts, administrative agencies involving claims of discrimination, sexual harassment, and retaliation. Brian, welcome back to the show.
Thanks again for having me, Mike.
Okay, straightforward topic, but man, just I think a mountain of data that we could unpack here. I just wanted to try to raise awareness. We talk about this law, that law, and how to stay compliant in best practices. Maybe just we step back here and think, what is the biggest risk to a small business owner, right? To a small business, mid-sized company where, okay, maybe I'm not doing something the way I should, and maybe I'm not handling my I-9s right. I get audited and I get fined, and these things can be expensive and troublesome. But I think the biggest existential threat that businesses face is lawsuits. And whether these lawsuits come from a disgruntled employee, or from an agency, these really, the dollar amounts can be so big that they are existential threats. Would you agree with that?
Yeah, absolutely. Whether it's, an individual issue or oftentimes, these lawsuits can, group employees together, class actions where, liability just grows exponentially.
So here's what I want to do. We picked 5. What I would probably consider the 5 most common, probably in this order, but not necessarily. So I want to tee up the topic, and you just give some use cases here where areas where maybe somebody thought they were doing nothing wrong. And because we always try to give the audience here the benefit of the doubt. I don't think anybody is trying to break laws here, right? But part of HR is being proactive, a bit of an insurance policy, if you will, to get ahead of these things to prevent these expensive lawsuits and fines. So the first one I want to talk about and unpack here is around discrimination and retaliation. And specifically, there's a use case I want to explore. There's a moving company in California. Part of their advertising was that they, kind of touted this fit staff, this not necessarily even young, but this young, fit, buff kind of staff. I think probably there is a component of, yes, we're physically fit enough and strong enough to actually handle the workload, but there's maybe a bit of a sex appeal. It was part of the advertising, part of the culture. They had no idea that they were doing anything wrong, and they got hit hard. Can you kind of give us the rest of the story here?
Yeah, so this case, it was something where the EEOC was investigating this moving company for a number of years, which, isn't necessarily the EEOC's MO. They receive complaints and pursue them. But, this one they initiated on their own. They were monitoring it. And they recently filed a claim against this moving company. And like you said, the company said, hey, we didn't think we were doing anything wrong. We advertise as, these young, maybe college students, young, fit, athletic people. And so, it brings up a very, interesting element of, the Title VII and, discrimination where, it's a small and it's a narrow exception. But this company, it may have a defense because there's something called a bona fide occupational qualification. That's a handful. We really just call it a BFOQ. And this is, again, I think we should start off taking a step back that the law says you cannot discriminate against employees based on a number of protected categories: race, religion, sex, age, things like that.
Right.
But if there's a BFOQ, a bona fide occupational qualification that applies to your business, then essentially what the law says is you might be able to, we won't say discriminate, but you might be able to make determinations and have qualifications based on protected categories. And so the requirement of this, and again, it's strict requirements, and we'd see if this moving company might fit it, would be that you can hire employees of just a specific protected category as long as that restriction is related to the business's particular characteristics or needs, and it's justified by the job's essential tasks, right? So,
can you give an example, Brian, where that would be, where the BFOQ would be legitimate and defensible?
Right. So, we've all seen, various, restaurants that might, show us, for instance, they might only hire women as servers, right? And look, it's really about the nature of that business, right? Because we all know that men also, or anyone can be a server. So it really looks at what the business is and what the essence of that business is, right? These are all the inquiries the EEOC and a judge would look into, right? What is this business? What is it about, right?
No.
So it might be easier to kind of show ones that don't apply, right? For instance, so number one, this never applies to race. A BFOQ, you can never apply race, but somewhat similar, we can apply it to national origin, right? So let's say we have a company that operates a tutoring service or school for people interested in learning French. And so the company says they are only going to hire native-born French people as their instructors. The employer might say this is necessary to provide role models for the students, maybe, but in reality, the essence of the business is not providing role models or providing a real French person, right? The essence of the business is teaching French. So, that would be one where the EOC would say, no, you can't just hire, people of French origin because that's not the essence of your business. Similarly, and these are areas where I think employers often get into trouble when we apply this to sex. And so I think, again, using a number of justifications that don't establish a BFQ might be the best way to learn this, right? So, for instance, you have an employer that says, no women can work on the loading dock of the warehouse because, we need to lift packages of, 100 pounds or more. And, they say, well, we don't have a woman who can lift 100 pounds. So that's our requirement. But again, women can carry heavy things, and some women, just like some men, can carry things over 100 pounds. So that would
some men can't.
Exactly, right? So it's not something that's dependent on sex, right? Strength is not dependent on sex. So, a few other justifications. And again, these are ones that I've seen, when employers aren't even thinking about a BFOQ, but just, oftentimes employers will think, I can, that they think they're being, nice or kind by saying, women shouldn't do this job because the work is too undangerous or unpleasant. No,
this is one of those areas that I really give employers the benefit of the doubt. I think back to my dad. He was an entrepreneur. He's a good man, and he never would have let a female do some jobs in some of his businesses because that was quote unquote man's work. And he wasn't trying to be a sexist pig. He was trying to be chivalrous. Right. And so I think what's important, and we always come back to here, is you think protected classes, you can't hire based on an age, based on a gender, a sexual orientation, you have to identify the qualifications of the job. Does the job require lifting over X number of pounds? Does the job require being tall enough to reach a certain height, right? Does the job require, and it's what the job requires, not whom you think are the only people that could fit that job, right?
100%, right? It's not about who can perform it. It's about what we need done. And, you find qualified people who can do it, and you don't need to limit it based on characteristics. So, yeah. Right. I think the lesson here is really that, BFOQs are not necessarily the way to go, and companies that think they might have some business need for only hiring people of a certain religion or sex or national origin, most likely than not, it's not going to pass muster, right?
Can you tell us what happened in this case with the moving company? What was the outcome here?
I think it's in its early. I still believe it's in litigation right now. I don't think it's been resolved yet. I believe that there is information out there that the EEOC was seeking millions in terms of a settlement. I think their last demand was somewhere around $5 million to settle the case. The company, it looks like, was still, nowhere close to that. So, this is likely one that's going to be litigated. And, look, for that company, it's a big expense now, whether they settle or whether they litigate. And that's why the company, look, they're saying we thought we were doing nothing wrong. Now, again, I can't be certain about this, but, one would hope, they looked into this, maybe spoke to, HR people, spoke to legal people, right, to figure out, if this is the right type of arrangement. So, that's what I would suggest, looking into these beforehand. And, if you're going to try to exclude a class of people, that should always be a red flag. And you should be considering, is there any less restriction, or should I just have job requirements and interview people and see who can, perform the job and hire those people regardless?
And to be clear, in this case, so the name of the company, and I'll share it because you can Google it and find it. It's Meathead Movers. So you might think, okay, it's a pretty bro name of a company. Maybe this is a sex discrimination, like they're only hiring men because there's a certain sex appeal of their advertising. This is actually an age discrimination case, right? And so, again, I go back to my dad. It's like, okay, I could see how he could have made this mistake based on sex, but he certainly could have made it and said, no, let the young guy do that, not the old guy. He probably would have even said those words, right? And I think there's a lot of employers, they really, really, really mean well. And perhaps the population who self-selects for these jobs, it seems logical that it will skew younger. It will skew male. But again, you can't select based on that. You have to select based on the criteria of the job. What are the requirements to perform the job? And this is where they made their mistake based on age.
Exactly.
At least allegedly. At least allegedly, if it's still an active.
Exactly. That's they will their defense will likely be asserting a BFOQ, but I think that's a lesson to employers that again, treat people of protected categories, treat people equally, focus on the job requirements, because the exceptions to that are very narrow, and you're going to need to really prove that would be required by your business, and it's a high hurdle.
And I'll say, I know nothing about Meathead Movers. Maybe I'm being too critical and making fun of the name a little bit in jest here. Mad respect for all entrepreneurs. Running a business is hard. Growing a business is harder. So these are just things that you got to be on the lookout for. I assume they did not set out intending to break any laws. They probably just thought, in old school mindset, I need a bunch of young men to go move a bunch of furniture. In that got them in trouble. Even if they win this case, this is going to cost a freaking fortune to defend themselves, even if it turns out they're right. Okay, let's move on to the next one. Harassment. So first topic, discrimination, retaliation. I think you set up how these aren't always as clear cut as they may seem, but I think discrimination generally is probably a little more clear cut than harassment. Man, there are the clear cases on ends of spectrum here. Oh, clearly that was harassment, but this is one where employers get in hot water all the time because they just either they're unaware of what's happening in their shop or they didn't think this was harassment behavior. Unpack this one for us.
Yeah. So exactly. I mean, look, we could talk about harassment issues, for hours, right? Because this can come in so many different forms. Yeah, obviously, the one that typically comes to mind is, sexual harassment, right? That's harassment based on sex and, but it can apply to, other protected categories too, right? You can have a hostile work environment based on race where, the workplace is permeated with, people making inappropriate comments or conduct related to someone's race or, religion. So, again, even though we probably think of sex when we're talking harassment, it applies to all these protected categories. And again, right, it's generally unwanted conduct. And, when we're talking about sex, it can be sexual advances or touching, and it's unwelcome, right? So, I think, there are two ways, right? There's quid pro quo, which is, conditioning some benefit on, on submission to, right, a sexual favor, something like that. That's easy to identify. Often it is, right? And it's certainly wrong, right? And then there's just the general hostile work environment where we're talking about severe, pervasive, conduct that just focuses on one of these protected categories. And look, in the end, it's making someone's work environment pretty bad, right? It's offensive, it's intimidating. So I think, a couple examples of this, right? Hostile work environment, right? So there's always a question of, right, when do things cross the line over, just general workplace banter versus, what is actionable, right? So, in this scenario, in this case, there was a coworker who was, making, gender-based comments to a woman and asked her, inappropriate comments, right? Some of it was just telling dirty jokes, right? Which many employers might not see as something bad, but it's not appropriate for the workplace. So there were dirty jokes. And then, look, we're talking about some physical touching, but it was not at the level of groping. It was more like along the lines of passing by someone and, kind of brushing by them, or when you're sitting with them, putting a hand on the arm, things like that, which, again, depending on people's experience, they might not think that's so offensive. But again, is it appropriate for the workplace? And the answer is it is not. Right?
And you and I did a show on this exact topic. This is one of those things that I think employers get in such bad trouble because of naivete about what the law is. And you said the word, I think 2 or 3 times. It's the right word. It's unwanted, right? That I'm assuming no one watching today is expecting sexual favors in return for a promotion or a pay raise. I mean, of course that does happen, but giving everybody the benefit of the doubt, if you're watching this show, you probably aren't that person. But it's the things that happen in your shop that either you don't know about, but you're responsible for that environment, and employees receiving unwanted jokes, words, touches, whatever, or the things that you think are just innocent. It's you don't go up to somebody of your same sex and nudge them with the hip, say, "Hey, how you doing today?" And so, but you do it with one person, and maybe it's not all people of that gender or that sex, but it's the one person. How could they not think that has some sexual orientation, right? It's these things that employers just think this is no big deal. That's where they get in trouble. So, Brian, how do you give practical guidance to business owners in that context that still have to like live in a real world, and they don't want some ice water in the veins, cold, legalistic culture in their business. They want to have a fun relational environment.
Yeah, no, it's a great point, and I think one of the keys is having an open door policy, right, and setting a culture where look, you can have that fun, but employees understand and know because they have written policies and they've seen this implemented in practice that if they have complaints, they know the various people they can go to, and they know that it'll be taken seriously, right? That's the culture that we should strive for, because again, in a lot of these hostile work environment and harassment cases, things could have really stopped early on if the company had an effective complaint procedure. But often what we find is, even though they might have had some procedure in writing about who to complain to, that the culture was not one of an open door type of policy where instead employees felt like they might be subjected to retaliation or a demotion, or their hours might get taken away if they report this. And that's why it's important that employees know various outlets that they can report these things to, because in the case I was discussing earlier, right, one of the problems was the supervisor and the alleged harasser were very good friends. And so the employee felt that she couldn't go to the supervisor because she was afraid of that relationship. And so I think it's so important to set that culture, have people understand they can come forward with things and it will be taken seriously. And look, a lot of that starts with training of the managers and supervisors, right? Not just for the managers and supervisors to understand, what they should do and what they should not do, right? Appropriate conduct, everyone should know. But, supervisors really need to understand their obligations go a little bit higher than other employees, where if they see something, if they know about something, whether it's reported to them or not, or they just observe it, they need to go and report that to HR or report it up the chain of command, because, it's these types of situations, right? Hostile work environment claims, they don't occur. They don't, they're not created overnight, right? It needs to be severe and pervasive. So we're typically not talking about a one-time incident or something that went on for 1 week.
Brian, I suspect not everybody listening is going to interpret the word severe the same way. I mean, just walking through life every day, we all know, we can all point to somebody like, oh, they are so overreacting. And maybe you're right. And maybe they're an edge case. Or maybe you're wrong. But people generally who think that's the problem. Can you make this more real for folks and maybe give an example of a court case, if you know one off the top of your head? Like, what happened? What was the cost? What was the outcome?
Yeah. So, look, here's one. It was a restaurant and, a bartender. And we're not talking about this bartender being harassed by customers. It was the owner and a manager, right? That, again, physical contacts. But then here's a key, right? It wasn't necessarily, oh, I'll give you a promotion, or, we'll only hire you if you, submit to my advances. It was much more subtle than that. It was, we're only going to give you the most lucrative shifts if you submit to my advances. And so this individual did not. Someone else did submit to those advances, and they were given those more lucrative shifts where, tips would be better. So again, looking at that, it's not as if the, hours were cut, right? She kept the same hours, but her, income went down. And so in that one, once she complained, she was terminated. So there's a retaliatory aspect to it as well.
Yeah.
And it was a total $2.5 million verdict, jury verdict, $1 million in punitive damages and another $1.5 million in compensatory damages, including, emotional distress, pain and suffering. And that's real. And that, that bartender, right, probably a minimum wage employee, right? So, damages are often
Yeah.
going to be, they're not going to be proportional to, the level of the employee. It's proportional to the amount of harm that's imposed. And so, and I think one thing we never really mention in these verdicts, right? Because that's a $2.5 million verdict to get through a jury trial. That company probably had at least $500,000 in attorney's fees as well, right, to get through a trial. So the cost
and
is
just how many small businesses, and I'll say small, under 50 employees, how many survive? Most of them can't afford to pay the $500,000 in legal fees all at once. They're going to do pay as you go, and they're going to be paying off that attorney for a long time, probably. They probably can't write the check. The check would bounce on the $2.5 million, right? I mean, these truly are existential threats. This is just stuff you can't mess around with.
Yeah, exactly.
Any other cases or examples you want to talk about that you think people need to understand around harassment?
Yeah, look, I think, one of the, I mentioned the complaint procedures. But, I think, again, we talk about this with respect to discrimination, but also harassment. And the biggest key is just consistency among employees, right? The consistency of how you treat them, the consistency of how you apply your company's policies, right? And so, again, if managers have policies and they're able to apply them, then you're right. There should always be someone up above them making sure that it's done, consistently, right? It can be very simple things, right? We can, terminate one person because they're a no call, no show for 3 days in a row. But then, when it's, someone under 40, maybe we're not doing that. So, those things, even if there are legitimate reasons for treating people differently, again, that's fine, but document those, right? We treat people consistently and we document, discipline. So,
Brian, just for sake of time, I'm going to move us, but I want you to hit one more topic on harassment, because I think this is maybe one of the biggest blind spots for small business owners. Is their responsibility for the environment. I was literally talking to a small business owner yesterday. They had a Christmas party over the weekend. After the Christmas party, 2 employees met their husbands in a bar in the same strip mall, lots of alcohol involved, and there was an altercation between these 2 couples. Monday morning, the argument publicly continues in the business. It's the stuff that happens outside of work that creeps in, and owners think, oh, that's their problem, not my problem. But as an owner, you still have a responsibility for maintaining what is acceptable behavior in your business. Can you speak to that, please?
Absolutely. So, let's start with the rule that flows from everything you just said. Harassment can occur anywhere, right? It's not limited to the office. It's not limited to the holiday party. It can occur outside of those areas. It can occur online. And so, a company saying, hey, we're not going to deal with you, the 2 of you. These are issues you had, with your families outside of here, go deal with it on your own time, right? That's not an appropriate response, right? Because this becomes a workplace issue because it's involving 2 of your employees and potentially inappropriate conduct, right? So, I think, certainly, owners need to get over that, that mental block that, if it's not on the clock, it's not what we're dealing with. And similarly, right, it doesn't even need to be your manager or your supervisors or your employees who are doing the harassing, right? It can be a vendor who's coming in and dealing with one of your employees. It can be customers dealing with your employees. So, harassment is just very broad, right? And so, companies, employers should not think, there are these, bright lines where, after hours, I don't deal with it, right? That's not what you're held to as an employer.
Tell me if I have this right. So here's a case: is owner, this person, he didn't want to know, he didn't want to be involved, but one person started talking about it first thing when they came in Monday morning, and so there's no such thing. You're not going to stand in front of a judge and say, "Oh, but that was off the record," or "That happened off hours." Knowledge is knowledge. When you know something happened, you have to address it. And so it doesn't mean that the owner had to jump in and try to be an arbiter of this ridiculousness that happened in the bar after the holiday party. What the owner's responsibility is to say, "Hey, not sure what happened. I don't want to know. I'd prefer if you keep me out of it. But this is the place of business, and these are the rules that are of acceptable behavior here. My request is that you don't let this interfere with our work. You don't talk about this at work. My personal recommendation, after work, I think you guys should go figure this out so you don't carry any ill feelings. But this is what's going to be acceptable behavior in this business, and this is what's not." Is that...
Yeah, exactly. And look, even still, I think you might go further that, look, even, you shouldn't be having inappropriate communications outside of this. So we need to make sure that you're able to move past this and deal with each other professionally, whether it's, because again, right, if as the moment they leave work, one is just, blasting the other and putting, inappropriate things on, social media about the other, that continues to spill into the workplace. So yeah, these are tricky issues. And look, the thing with harassment is, no two issues are the same. There's always some background, different facts. But again, that's why, you want people to feel comfortable to bring this up so that, look, the company can figure out what, if anything, it can do to make it a better work environment for all these people. So
to listeners, no surprise that the lawyer here said to go a little bit further than the business guy. But point taken here, I do think it's fair to say when these things arise, eventually you're going to sit in front of a judge or an arbiter. And the laws are what the laws are. They're black and white. They're words on paper. But at the end of the day, a human being, a judge or arbiter, is going to make decisions. And the more leaning in you are, trying to address, trying to create a safe work environment, trying to create a healthy work environment, trying to stamp out this kind of issues, even if you fumble your way through it and do it poorly, it's going to reflect so much better on you when it comes time to decision than if you just did nothing and just turned a blind eye. That's not an exaggeration, is it, Brian?
No, that's absolutely correct. It's the cases I see with the most damages, with the worst outcomes for the employers, are ones where things are brushed under the rug and just not dealt with, where complaints are ignored. Yeah. So again, you might not always know how to best handle a complaint, but the starting point is knowing you need to handle it and starting. And then, look, there are resources like Assure software. There are resources to help you through that. But understanding it's something you have to deal with is the first part.
Okay, let's move on to the next, probably most common. And I think this one is more legalistic because people get in trouble for breaking rules they didn't know existed, but it's not. That's your problem. It is your responsibility to know the law. You don't get to tell the police officer, "Well, I didn't know that the speed limit went from 55 down to 45. I didn't see that sign." You're still getting the ticket. It's your responsibility to know the law. And so this is the category of wage and hour. And this is where state and federal departments of labor get involved. Take us through where is it that employers make the biggest mistakes, find themselves fined, sued? How do these actions come up? And then ultimately, what should they do to prevent?
Yeah. So no, it's great. You mentioned the Department of Labor. That's often something, employers overlook, right? You think of private lawsuits are typically the way, wage claims are coming about, but there's the U.S. Department of Labor and then, state departments. And they are, the federal Department of Labor is certainly active. State to state, it varies. And they will initiate their own investigations. The DOL can, file, actions if they're not able to resolve matters. And so I think the biggest thing we have to be concerned about in terms of wage and hour exposure is that unlike your typical discrimination or harassment claim, which usually just involves a single employee, wage and hour matters can involve lots of employees. And, basically, if your company is making a mistake, whether you know about it or not, right? Intent is not even a requirement. It's just whether or not you got it right here.
Yeah.
But, if you have multiple employees that your practice or policy applies to, the whole, whether it's, all your sales force or all the warehouse workers or what have you, that is exposure beyond just one person. And so, maybe one person files the complaint, but the DOL might want to, audit your entire company or audit that entire classification. Or if we're in private litigation, we're talking a class action. And that is often the leverage that plaintiffs' attorneys and the DOL has, that these can become, enormous, grouped claims. And so, compliance is so important. So, I think, we'll go through a few things. What we'll really focus on here is, your non-exempt employees. Those are your employees that get an hourly rate of pay. And when they work over 40 hours in a work week, they're getting overtime at time and a half their regular rate. So, I recently saw, I thought this was a good case to bring up, not to scare anyone, but it's just, notable because it's historic. The Department of Labor in 2023 obtained its largest Fair Labor Standards Act, that's the federal wage and hour law, the largest FLSA verdict in its history. This was a federal case in Pennsylvania, and the DOL obtained a $22 million verdict covering a class of over 7,500 employees. And this raises an interesting issue because in this case, the damages were not enormous on a per person basis, right? This case was about, it was a battery making plant where the laborers were subject to, interacting with, toxic chemicals and such. And so there was certain, donning and doffing of protective equipment and, showering after the shift, which, again, these went beyond just regular generic safety measures. These were specific to, the work being done and what they were being exposed to. Yeah. And the company didn't pay the employees for that time. It could have been just, maybe 5 minutes at the beginning of the shift or 10 minutes at the end. It depended. But, not huge amounts of time, but it adds up over, the statutory period is 3 years. And then, over 7,000 employees, these things add up.
Yeah.
So, I think, that case teaches us, look, if you have any work, anything productive or even potentially not productive work that your employees are doing before they clock in for the day or after they clock in for the day, even if it's just changing clothes or something like that in a locker room, you should look into that. You should consider whether on a daily basis there might be a few minutes of time you're not capturing. Because again, to an employer, 5 minutes at the beginning, 5 minutes at the end of the day, not a big issue. To an employee, that's 10 minutes a day, almost an hour a week. That's, dozens of hours over a year and add in.
And like you say, it's not, in this case, it wasn't having to put on, hey, you got to get dressed for work anyway. You got to shower and be presentable when you come to work anyway. This was required because of the type of chemicals and whatnot that they were exposed to. So you had to do it. It really was part of the job.
Right. Yeah. And what the courts say is if the time spent doing these things is indispensable to the duties the employee is performing, then it's compensable. And so, again, the courts analyze each one, again, no two of these are necessarily alike, what employees are doing or what the job they then do after they change. But it's certainly something that for an employer, if you're not capturing that type of time, look, you may be right. You might not. It might not be compensable, but it's something to look into and ensure that you're doing it the right way.
Right.
And then,
you know what? And for anybody listening, saying, "Oh, that's big company stuff." I mean, last year it wasn't just that the DOL. I think I have this right. It was that was a record single verdict, but I want to say DOL has captured in 2023 over $100 million in just fines, penalties for improperly, whether intentional or not, paying employees, and this includes very small firms.
right. No, exactly. I mean, look, I deal with, the Department of Labor all the time. And look, it can range from a mom and pop shop to, a national or or an international, company, right? They don't discriminate. If they find the complaint, they're going to look at it, and they're going to pursue a claim, at a small pizza shop the same way they would pursue a claim at a much larger company.
Right.
Because
Could you put in a couple buckets for all wage and hour? It's a really big category. And maybe I'll set up first. So if you think about wage and hour, there was always 1938 the Fair Labor Standards Act first passed FLSA, and so you had a single overtime, you had a single minimum wage, you had basic record keeping requirements. But along about 10, like maybe 12 years ago, all of a sudden a couple states started saying that they would have their own minimum wage. Well, today I think there's something like 155 unique jurisdictions between states and counties and city municipalities that they layer on each other. And so if you're some states that don't, they just adopt the federal minimum wage. Other states, okay, we have a different one. It's usually higher. But others, it might be, okay, well, if you're in this city or this municipality and you offer benefits, this is your minimum wage. If you don't offer benefits, it's this. Or if you're above or below this employee threshold, that's just the minimum wage component. The states in these local municipalities also layering on leave types, paid leave, unpaid leave, what's required, what's not required, overtime rules. Is it 8 in a day? Is it 40 in a week? Are there combinations thereof? My point here is these things just are getting so complex as they layer on top of each other, sometimes conflicting with each other, that, man, businesses are just running blind here. And there's probably way too much that we could ever even unpack all of it. Give like the top 3 areas that you see businesses unintentionally get in trouble with wage and hour.
Sure. So the first one that I see way too often is not having the right type of time records for your hourly employees. And so when we say the right type, really, I'm saying it can be anything. It can be any type of contemporaneous time tracking, right? So we all know, we've got biometrics, time clocks. Those are great and very effective and create, great, documentation, and it's, it can be electronic. But, look, for some small businesses, it can even be as easy as giving a piece of paper to the employee and saying, write down the time you come in each morning and the time you leave. And, when you take a break, write down the time you go out and the time you get back. So, having those contemporaneous time records of the start and end times, just so important. And, if you don't have those, number one, you're already violating the law by not keeping the records.
Yeah.
And number two, you're going to be way behind the 8 ball in disproving the employee's allegations that they worked. They'll come and say, we worked 70 hours a week. You're going to say, no, it was 30. But without time records, very difficult. So, that's number one. Time records are just so important. The second issue I see a whole lot of, it somewhat relates to, that issue, but it's knowing who can be paid an hourly rate and who can be paid, a salary. So really, we start with anyone can be paid an hourly rate in overtime, but there are only certain exemptions, certain categories of employees who can be paid a salary, right? Yeah. And so there are rules, both, as you mentioned, there's going to be the federal rule about that, but your state might have even stricter requirements than the FLSA about, what their duties are and how much they need to be paid on a salary each week in order to qualify for the exemption. So that's a
Yeah,
second one.
this is a huge one. I was just talking to somebody else this week. In this, I would encourage everybody to go check out. I think Brian, you and I did a show on this a few weeks back. I think we're probably going to do another one very soon. DOL has proposed a new minimum, not minimum wage, but a new minimum salary for exempt employees. It's going to rock some people's world. This is a big, big change. When and probably if this thing happens, which is pretty soon. So I invite everybody to go look at our past recording of that one, and stay tuned for the coming update. But so many business owners, I think, oh, clearly this is an hourly job. Hey, I'm gonna put you on salary. Well, there's no such thing. Not in the eyes of the law, anyway. Like, hey, I want to even out your income. I want to make it more predictable. I want you to feel a sense of prestige, like you've leveled up and now you're on salary. That's not how the law looks at it. There are very clear laws, not rules, not guidelines, not suggestions. There are clear laws on whether you do or don't qualify as an exempt employee, meaning you're exempt from overtime, or you're non-exempt. It's super black and white, right?
Exactly.
Okay.
And look, and where there are gray areas, look, that's where you should seek guidance, from an HR resource, from an attorney, right? Because that's when, look, if you try your best, you seek outside resources to get, to understand how you should be paying someone, and you make a mistake, you'll still owe them those unpaid wages, but it's a potential way to avoid, the liquidated damages, which basically double the unpaid wages.
Right. Okay. So keeping time records, exempt versus non-exempt classification. What's number 3 for wage and hour?
Yeah. And I think a big one, and I'd group these together, and I know we've discussed this, previously. I would talk about, travel time and break time. Employers really need to understand, when a break is truly not compensable. Same way with travel time, when it's not compensable versus when it's going to be compensable. Again, I think we did a pretty deep dive on that previously, so people can check that out. But certainly, don't just employers shouldn't just think they're on a break. It's not compensable. You need to make sure they're not working during that break, right? They're completely relieved of their duties, right? They're not, eating lunch at their desk and getting interrupted by a customer call, right? That 5-minute customer call in the middle of their 30-minute break could mean that whole break is now compensable. And
maybe not even take the call, but are you truly, is that time truly yours to do with what you want, or are you required to take the call in case it comes, right? Because now you're at work.
Right. Right. Are you, even if you don't take a call, were you told you had to stay at your desk to eat lunch in case you got a call, right? That's limiting you. Now you can't go out and enjoy it your own free time. So there's a lot of nuance there, but understanding that there can be issues and looking into that's the first step.
Brian, I'm gonna try to speed us through our last couple topics. We can and have done hour-long segments on each of these in and of themselves, but let's hit the highlights. So topic number 4 is this: failure to provide reasonable accommodations. Give us an example where somebody thought they did nothing wrong. What did they do wrong? What was the cost? What happened? And how should employers be thinking about being proactive here?
Yeah. So, I have an example, and I like it because it hits on, mental health issues, which is something that society, we're seeing more discussion of it at large. But the law, it's always applied, equally to physical, disabilities, just like mental disabilities. Right. So, in this one case, right, an employee didn't want a party for his birthday. He told the office manager, I suffer from an anxiety disorder. Parties are no good. Please don't do that. Something got lost in communication there. They ended up having a party. The employee has a panic attack, goes home, right? Then comes back a day or two later, and the supervisor confronts the employee about, his, what he thought was a negative reaction to the birthday party, triggers yet another panic attack. Then you have an issue where 3 days later, the company terminates this employee because the manager is questioning whether this person is quote unquote stable, and the other employees in the office are saying their concerns for their safety. They're frightened about what occurred, and so they fire this employee. Now, we'll talk about what they should have done, but that resulted in a $450,000 verdict. Right? It was $300,000 in emotional distress, over $100,000 in lost wages, and so the takeaway from this is a good reminder that, number one, right, mental health issues can be disabilities. And the ADA, the Americans with Disabilities Act, covers mental or physical impairments that substantially limit one or more major life activities. And so again, we're talking about accommodations, right? So employers should understand their obligations to accommodate both physical disabilities and mental ones. And so, the ADA even requires employers to go a little bit beyond what they might have to do otherwise when it comes to some mental disabilities, specifically where an employer can easily see that there is a mental impairment, and that it's possible that because of that, the employee is not really aware of the impact of their behavior, right? That it's incumbent on the employer to talk to them about a reasonable accommodation, right? The same way that if an employer is aware that an individual has a mental impairment, right, and they're seeing there's poor job performance, right, the guidance there would typically be, that the employer should initiate the interactive process and discuss, if they might need anything, right?
Brian, is there and we're basically at time, so I want to give it 2 minutes on FMLA. But is the issue here that the employee gave notice of the concerns? Hey, I have anxiety issues, and therefore, from that moment forward, the onus is on the employer to provide reasonable accommodations for that anxiety disorder, right?
Right. So,
because I can imagine a scenario if I have an employee, and maybe he's quiet and doesn't talk much, and I really don't have much of a relationship with him, and I actually want to do something really nice for him, and so I throw him a birthday party, and he freaks out and leaves. I'm like, well, you don't just get to leave work, and second offense, no, you're gone. I can see that could seem reasonable. Am I getting it right that the difference here is that notice was given?
Right. Notice was given. And I think, look, before we get to providing a reasonable accommodation, and I think a lot of employers, think about it this way. They're just thinking, all right, now I got to give an accommodation. What is that? But think about the interactive process, right? There's supposed to be this interactive process before that accommodation is given about, hey, is there something that you need? What can we do for you? How can we, help you succeed, right? Those are the types of conversations an employer might have if they're, not sure if this is something related to, that a mental impairment, right? Or something, or even, physical. So I think it's about having these conversations because, look, at the end of the day, regardless of what the law says, it is much easier for an employer to keep an employee and help them succeed than to fire them, search for a new employee, hire them, train them, and then see if that one works out, right? So even taking the ADA out of the equation, it's something where, you should be seeing how you can help your employees, succeed. And again, if you have information that the employee, has a disability, again, the law might not always necessarily say, employer, you need to go to them, but, a request for an accommodation doesn't need to be, there are no magic words. So, some employers, in my experience, in some of the litigation, kind of try to skirt around that. Like they probably know that person needs something, but, hey, you didn't request the accommodation.
Yeah.
Oftentimes, the issue will be, well, you should have at least had a discussion,
And
had
just
an
like we talked
interaction.
earlier, these things get the law is the law, but these things, the judgments are awarded. In this case, a $450,000 judgment. Holy cow! It's human beings that dispense these things, and so I can just imagine that's you, and whether you think this is a horrible case and this is a sign of what's wrong with America, or you think that poor gentleman, how dare they treat him so poorly. I don't care where you fall in that spectrum. Just got to imagine you're sitting in front of a judge, and were you I don't care, go rub some dirt on it, you whatever superlative, or hey, I want you to be successful here. Tell me what I can do to accommodate. And then I forgot about it and had the birthday party anyway. Which one is the judge going to throw the book at, right? Because at the end of the day, you're going to make mistakes. You can't be perfect in how you handle these things, but intent and your behavior matters a whole heck of a lot.
Yeah. I think you summed up that case right then and there in those couple sentences. Exactly. If they had done the birthday party, but afterwards realized, let's discuss with him, how can we make this work better for you? Instead, they went the other way, right? Rub some dirt on it. Bye. Right.
Yeah. Right. All right. We're at time. Just real quick, FMLA, ADA, where is it that employers get themselves in trouble here?
Yep. So I think real simply, look, we can't get into the FMLA in 5 minutes, let alone 10 or 15, but there's a lot there to unpack. But I think when you have employees who need leave, you should always be looking at both the FMLA, if it applies to your company, right? That's 50 or more employees within a 75-mile radius, and the ADA, which applies to employers of 15 employees or more. So it's important to understand that leave can come up under one or both of those statutes, and that even an employee could take their 12 weeks of FMLA protected leave, and then there might need to be a reasonable accommodation under the ADA after that for some additional leave. So I think it's just understanding, what laws apply to you. And again, as you said earlier, Mike, there could be state and even city leave laws that make this process even, more of a complication for employers. But the key is figuring out those laws, getting help if you need that, having the right policies in place, and then training managers, as we always discuss, right, when it comes to leave, right, to how to recognize a request for leave or a need. And then really internally for the company, knowing how to administer these types of leaves. Certainly there's some more requirements as it pertains to FMLA, but understanding that these are the types of leaves that are available and considering, what the employee might be entitled to, very important. Don't just think, ADA, leave of absence as an accommodation, right? That, FMLA could apply too. Right. State laws could apply as well.
Right. All right. So top 5 areas that we talked about where employers find themselves at the wrong end of a lawsuit. It's discrimination in combination, especially with retaliation. It's harassment. It's wage and hour. It's failure to provide reasonable accommodations, and leave types around FMLA. Brian, I think if I had to give one piece of advice for employers, if you're at a big companies have HR departments. Mid-sized companies have at least HR staff that are certified, SHRM certified professionals. They know these laws. They can help give you guidance. The average small business doesn't. They're white knuckling it. Of course, it is your responsibility to know the laws. We'd love to help you. Brian would love to help you, but get professional help. But intent matters. Documentation matters. Behavior matters. And if you just treat people with the utmost respect, it's going to go a heck of a long ways. So, Brian, anything you want to add in closing?
No, I echo what you say that, look, if you're a small company dealing with this, it can be overwhelming. But there are benefits to looking into this, to complying, to getting outside external help to comply. It's not just going to make you more compliant and give you less legal exposure, but these all contribute to better workplace, better culture, which should have the impact of minimizing your potential legal risks.
Yeah. Brian, always enjoyed talking to you. Thank you. And to everyone else, thank you so much. Until next week.
At Assure, we build human capital management software and services that help 90,000 companies like yours attract, develop, and retain great people. Our low upfront costs and affordable subscription model allow you to save cash to invest in things that drive growth, not overhead. To learn more about how Assure can help you claim up to $26,000 per employee with the Employee Retention Tax Credit, automate your payroll, and build productive teams that are compliant with ever-changing HR laws, visit AssureSoftware.com.